Good morning, everyone, and welcome to the virtual HR Cafe. This is David Daugherty speaking, and this is the first time I've had the opportunity to be with you in several months, and I am excited to be here, and I'm really excited about this topic that we're going to hear today because in today's world and environment that we're operating in, it's a real guessing game whether we're doing everything exactly right. The Chamber of Commerce loves to host this on a bi-monthly basis. We're excited to welcome Joanie Winters of the Winters Law Firm. Joanie is an employment attorney and practices out of her office in Chester, South Carolina. She also teaches at Winthrop University and is a member of the Catawba Workforce Investment Board. The topic today is your employee handbook legal. Our communications and investment specialist, Janet Balsiger, is going to be the moderator of today's meeting. And if you have any questions, you will be muted throughout the program. Please use the chat box to communicate during the presentation. If you're calling in, please wait until the end of the session to be unmuted and allow you to ask your questions. Joanie, thank you so much for taking this time to join us and share your expertise today, and we're going to turn it over to you.
Well, thank you, David. Welcome back. I'm always excited about being in Greenwood, although I'd rather be in Greenwood than be on a Zoom or a WebEx, or I forget what venue we're using, but one of the above. And it's always much better when we can kind of chat and have lunch, but this is what we've got to do right now, and hopefully not too much longer. And thanks to Janet for all her hard work in putting this together. This is awesome. And I sort of promised that I wouldn't talk about COVID again, but unfortunately, when we're talking about our employee handbooks, we're going to have to talk about COVID. But I promise this will not be entirely about COVID. It's going to be about your employee handbook. Because there's nothing worse than finding out that your handbook's not going to support you during a legal challenge. It's too late at that point. So we're going to talk about some things that you can do to shore up your handbook so you're not surprised at your next unemployment hearing or EEOC charge, which hopefully you don't get, but unfortunately because of COVID, I think we're going to see some of that down the road. So we're going to talk about employee handbooks. For those of you who are just on today for the first time, welcome to HR Cafe. David said the chamber enjoys hosting these. You have no idea how excited it is for me to be able to continue to do these, because it's really all about helping employers. And this is one of the areas that I see routinely getting employers into trouble. So with that, let's get started. And for those of you who know me, I'm not all about being an attorney. I was an HR director in my other life. And so a lot of what we'll talk about today is legal, but a lot of it will be practical as well. Okay, so remember when you write an employee handbook, you don't have one audience, you have many. So you've got exempt, non-exempt employees, and the rules are different for them. The thinking is different for them. Time off, FMLA, all of that. And so you may also have a potential employee looking at your handbook, depending on where you keep it. I just did some hiring for a client, actually hired an HR director, and of the 5 candidates that I interviewed, 3 of them had gone online and read the employee handbook, which to me was impressive. Now, again, they were applying for HR director position, so it wasn't completely surprising. However, it was satisfying that they were familiar with our policies. Very helpful. So you don't want to scare anybody away if you've got a handbook that is harsh or incomplete or just not current. That's a problem. And so your handbook is going to be your guideline of policies for your employees, okay? It's what to do, what not to do, things like that. You could also have adjudicators looking at this. An adjudicator is a judge, a state agency, unemployment office, maybe LLR gets a wage and hour complaint. And so they're going to look at your policies. If it's LLR, they want to see your overtime and your wage payments policies and your Fair Labor Standards policy. If it's an unemployment claim, they want to see the disciplinary action policy. And if you don't have those, you're going to be very, very challenged in fighting that complaint. Jury, certainly you don't want a jury pouring through your handbook, because that means you're in court. And certainly everyone's goal is, let's not get that far. Let's do things right so we don't even have legal challenges. But when you have a jury looking through your handbook, it better be right. Okay, so again, I'm that lawyer, but I'm also that former HR person. I like practical stuff. First question for me when I'm looking at handbooks is, what's the corporate culture? If you don't know what the corporate culture is, that's a whole different problem. But corporate cultures change. They sort of evolve over years. And so you need to know what the current corporate culture is, and that handbook has to be appropriate for that culture. So let's say your handbook was written for a large corporation, but you have 25 employees. That handbook's not going to work. It's designed for a very large workplace environment, and there are probably policies in there that don't even apply to you. If you have a company that's, let's say, an open office design firm, you develop websites or whatever, and no one has an office, everybody's sort of in an open room, and the handbook that you're using was written for manufacturing, that won't work either. And so it has to meet the culture and the needs of your organization. The handbook also has to be easy to read. If there's a bunch of legal mumbo jumbo in there, and this is coming from a lawyer, right? If that's in there, first of all, it's not necessary as long as you hit the legal points, and this doesn't have to be written in Latin. Secondly, it won't get read because the employee is going to look at it and say, oh, great, some lawyer wrote this, meaning some lawyer who doesn't understand our company. Also, make sure your handbook is not a procedures manual. This should be a policy manual, not a how-to. So I've seen handbooks that are sort of a conglomeration of policies and procedures, and it's confusing to most employees. Most employees don't need to know how to follow through with an FMLA request or what to do if someone requests an ADA accommodation. That's for supervisors. That's for HR. Employees just need to know, how do I submit a request for a reasonable accommodation? Don't expect your employees to actually read the whole handbook, because they won't do it. Lawyers like me are probably the only people on earth who actually sit down and read handbooks from cover to cover. It's my job, okay? It's not their job. Most of your employees will look at the handbook when they need something, when they need to request time off, when they need to request FMLA. That's when they'll look at the handbook. And so you can kind of preempt them not reading it with training. And I don't mean train from cover to cover, because you will put everybody to sleep. But maybe take a month, once a month, you train on one policy. So it's just snippets, not the whole book. Do the highlights, the really important things that you want employees to understand, and then take it little snips at a time. So if you have department meetings, if you have staff meetings, it's a great time to take 5 or 10 minutes to look at policies, 1 or 2. We've got a lot of issues right now with the George Floyd death, with understanding harassment and discrimination. I'd start with them. So if you have, again, a department head meeting or what have you, start with your discrimination policy, start with your harassment policy. Right now is a very good time to make sure your employees feel safe and secure in your workplace. Also, retraining is important. So you start with your onboarding, and most of the time you will hit those highlights of the handbook. But if I've been with you for 5 years, by now, a lot of the policies have changed. Perhaps the vision and the mission of the company has changed, but yet the one that's in the handbook is still the one from 5 years ago. Or I don't even know what the new one is, because it's been inserted and there's been no training on it. So review is a really good thing with your employees. Retrain on certain policies. Again, I mentioned 2 that I think are very critical right now. I often get the question, so do I just refresh the handbook or scrap the whole thing? That really depends on the quality of your current product. Oftentimes I get handed a handbook that's come off from what I affectionately refer to as Google University or the School of Google Law, which a lot of folks use, unfortunately. And they'll say to me, well, so your fees won't be quite as high because I've already done the heavy lifting, right? You're just reviewing this. And unfortunately, my response is, I'm going to have to spend so much time on collateral damage repair. I'm probably going to have to charge you twice of what I normally would charge, because if I have a clean slate, you tell me what your policies are, or just give me some of them. Let's start anew. If it's been 5 years, 7 years since you've done your handbook, it's really a good idea to start fresh. But a lot of it depends on how often you have updated your policies, how long it's been since the last update, and what's changed in your company or maybe even your industry as a whole. Okay, so let's look at some things we should never do. These are certainly things that I don't think anybody accumulated on this meeting would ever do, certainly not setting your hand on fire. Some other things we should never do apply to our handbook. They include mandatory language. So the first thing I want you to do when you go back to work is look for words that are mandatory: must, shall, will. And I've mentioned this at several HR cafes. These are dangerous words in most of your policies. Now, there are some policies where you want to have shall. Employees shall call in 1 hour prior to the beginning of their shift if they're not going to come to work. Okay, that's a shall, that's a mandatory. However, you want to be careful with the must and shall and wills on issues such as, say, holidays. Employees shall have 12 holidays every year. Well, that could change. We'll talk about how a better way to handle that in a couple of minutes. But when you're making something mandatory, be very careful. So particularly in your disciplinary policy, look for these words. An employee will be terminated if this happens. Well, make sure you mean that, because that is promissory. Promissory. You also don't want to promise lifelong employment. So when your employees are classified as regular, part-time, or introductory, some of you may call it probationary. That's not a word I like. That typically says I'm a brand new employee and I'm already in trouble. I'm on probation. Introductory is a softer word, and again, that's not a legal issue. That's coming from my HR hat. So when you change from introductory, so I have gone through my 90-day introductory period, what do I become? Do I become a permanent employee? If your handbook says that, your handbook says to me, I'm not at will. I'm permanent. You can't fire me under the at will premise because you've said I become permanent after 90 days. So scratch that word if you have it in there. Use the word regular. So after my introductory period, I become a regular full-time or a regular part-time employee. Again, I know that sounds really, really petty, but remember, lawyers make their living on words. Don't use entitling or contractual language. A lot of our handbooks may say that employees accrue PTO at a rate of X. The word accrual is contractual. And if you have any kind of policy that says if they leave without giving notice, they don't get their accumulated unused time. If you've said it was an accrual, you've said, I get it. You have promised me that it's accrued for me and you have to pay it out. Be careful of the word entitlement unless you're talking about Family and Medical Leave Act, certain laws that do entitle our employees to certain benefits. But if you're saying employees are entitled to take the following holidays off, or they're entitled to take PTO at X, you have just given them a contract on that time. And so if you fire them tomorrow, you've entitled them to the unused time. Use the word accumulation, unused accumulated time. Start to use that phrase to get rid of the contractual language. And don't forget at will. That's a very important policy, and we're going to talk about that next. So in 2004, the South Carolina Supreme Court said that at will, it was now a law. It used to be just a concept. 2004, they said, if your employee handbook has a disclaimer in the front that says this is not a contract. And unless you have an expressly written contract from this company, this employee handbook is not a contract. The law says that disclaimer has to be on your first page. Well, your cover is your first page, and then you probably have an index, and then you probably have a welcome to our company. And so by now we're on the 4th or 5th page. Put it behind the cover. The cover, there is case law that says the cover's not the first page, but everything else is not. So you want it between the cover and then whatever else follows the cover. It has to be conspicuous. It has to be underlined. To me, conspicuous means it's a fairly good size font. It's bold. Now the underline is required by the statute, so it must be underlined. It also must be signed by the employee. Okay, so that's a problem because it's signed by the employee, but where is it? It's in the handbook. So my recommendation to clients is always one in the handbook and then one for the personnel file. Have the employee sign both, because you need proof that that employee saw that at-will disclaimer and knows that the handbook is not a contract. I also, as a footer, it's kind of overkill, but when I'm in court, I like overkill. I put a footer that says not a contract in bold. It's about 14 fonts, so it's on the bottom of every page. It's impossible for an employee to say they didn't see that. So that's the at-will disclaimer. Make sure you've got that. If you don't have it and you're tidying up your handbook, make sure that's the first thing you fix. Fair Labor Standards Act and wage and hour, these are policies that are required. So a couple of years ago, actually it's been probably 12 years ago, FLSA was amended to include a salary basis requirement. So you have to have a policy in your handbook called a salary basis policy that tells your exempt employees what their rights are under FLSA as far as improper deductions and how they can complain if they think that they've been subjected to improper deductions. So you have to have that policy in there. It's informing your employees of their rights. Wage and hour, you have to have what's called a State Wage Payment Act policy, state wage payment or wage payments, whatever you want to call it. South Carolina requires you to have a policy in your handbook that tells your employees when, where, and how they're going to get paid. So they're going to get paid bi-weekly, by direct deposit, and they'll get a pay stub in the mail to their current address. Any of those things change, you have to notify them 7 days before the change. There is a form that's on the Labor Licensing and Regulation website for this. And so get that form, get it. If you haven't already used it, just tell your employees that you're refreshing all of their files, get it signed and get it in that file. You get audited by wage and hour and that's not in there, you'll have a problem. Family and Medical Leave Act, this is a required policy. You have to tell employees what their rights are under FMLA. We're going to talk about the FMLA policy and the EFMLA in a couple of minutes, but understand the standard FMLA must be in your handbook. Employees have to know how to apply for this time. They don't, as I said earlier, have to know what to do afterward. That's your supervisor's problem. Identify the work week, the work schedule. I already talked about that. That's your wage and hour form that you need to have. Drug testing policies. If you are testing your employees, whether it's pre-employment, post-accident, reasonable suspicion, or random, whatever it may be, you better have a policy that tells them that. Otherwise, you can't do drug testing. There are no surprises in employment. You cannot surprise employees. And if you have any adverse actions that your employee or your supervisors are allowed to take, you should have that in writing too. It's really required. I will tell you that you'll lose any EEOC charge, you'll lose any unemployment challenge if you don't have a policy on this. If you're just making it up as you're going along, you will lose those challenges. And so make sure you've got that. These are policies that are nice. Now, I'm going to reverse myself and say that I really do think some of them should be needed, should be required, but there's no law right now that actually requires you to have a policy. And some of them where you are required to tell employees their rights there's a poster, such as EEO and workers' comp. So they're in posters, but I prefer policies. So you should have a vision, a mission, and a history. If I'm a new if I'm a new employee of your company, I want to know what I'm walking into. I want to know how this company evolved. If I'm walking into a new company, I want to know how it started. If I'm walking into a company that's 50 years old, how did we get there? Because I'm going to be part of your future. So I want to know what the history is. When I worked in construction, when I started, the company had been formed in 1939, and we were quickly approaching our 50th anniversary. And we had, the company made some videos as far as the history, and the original owner of the company, and now the grandson of the original owner was in the video. And it was great. It was so exciting for me to learn all that history of a company that I wanted to be a part of. I wanted to be a member of the future. So these may be kind of nice, but I think they make your employees feel engaged and part of the company. EEO policy says that we will conduct all of our employment practices with equal employment opportunity. That's nice, but I think it's really reassuring to those employees who are in a protected class, come to work for you, and they want to see that. They want to know that this is, in fact, how the company operates. Now, affirmative action goes along with EEO, but in a different way. Affirmative action comes in two parts. So you have affirmative action, the noun. Everybody remembers from school, right? A noun is a person, place, or thing. So the noun affirmative action is a document. And the last one I did was about 200 pages long. It has a lot of statistical data in it, where my hiring concentrations are. Am I meeting my internal goals of diversity? Because it's not a quota system as many believe it is. It's not. It's actually a great tool if you don't feel your company is really meeting the diversity wants of the company. And so it identifies your deficiencies. And then in the affirmative action program, you identify what you're going to do about those discrepancies. How am I going to recruit differently to bring my diversity up to where I want it to be? So it's a great tool, but I will tell you it's very time consuming, it's very tedious. And if you don't have to have one, companies who have federal contracts of 50,000 or more have to have one. So being in construction, we had to have one, and I had to update it every year. But I found it to be, as I said, a great tool. So that's affirmative action, the noun. Affirmative action, the verb. Remember, verb is an action word. So affirmative action says you are an EEO employer. You do conduct all of your employment practices with affirmative action. And that's what makes you an EEO employer. So together they need each other, but they don't necessarily need the document. That's unless you're required by contract to do that. That's one of those things that's nice if y'all have the time, and I know HR has very little extra time. So understand the two nuances on affirmative action. Don't have your policy say, we have an affirmative action plan, because if somebody knocks on HR's door and says, I want to see the affirmative action plan, you're going to say, I don't have one. So be very careful with that phrase. It implies you have the noun, you have the book. Harassment and discrimination, I don't think these are just nice. I think these are necessary, right along with retaliation. Right now, we're living under a cloud with COVID and all of that, but we also have had some protests and marches and things of that nature due to blatant harassment, blatant discrimination. So the employees who work for you right now need to know that's not where they work. They don't work in an environment where there's harassment permitted or there's discrimination permitted. So it's a very good time to strengthen these two policies. And by the way, they should be in the front of your handbook, right behind all the other stuff. They should be your first policy. Harassment and discrimination, that's how important they are. Retaliation should be right behind it, because your employees should understand, if I need to complain, I think I've been discriminated against, and I complain, I need to know I'm not going to get fired for that complaint. I want to be able to complain without fear of losing my job. Workers' compensation, that's a nice policy to have. Again, I put it there because I think it should be in your handbook. It's not required by law. Following the workers' comp policy should have a light duty policy if you permit light duty. But remember, if you permit light duty for workers' comp, you have to permit light duty for pregnancy, for maybe COVID, for all sorts of other things. So when you open the light duty door, it stays open for other disabilities or needs. Benefits, I don't recommend benefits policies in your handbook. Benefits are subject to change. You may have dental insurance this year, but because of COVID, you've had to cut back on some of your company costs, and so dental's off the table. Well, now you have to redo your handbook if you mention it in your handbook. Be very careful with the words that are not mandatory. Use words like may. We may have the following benefits. And then refer to the summary plan document that is in the HR office. So I would not get real specific on benefits. Attendance, I get a lot of employers that say, why do I have to tell people they have to come to work? And why do I have to tell them they have to come to work on time? I hate to tell you folks, but it's going to get tougher just because of COVID and the things that the speed bumps that we've had to drive over. We do have to have a policy for this, particularly those of you who are in manufacturing. You probably have a policy that lays out points. If you do have a point system, perhaps you have suspended the point system during COVID. When things eventually come back to normal and perhaps you are there, you've gotten everybody back to work, and you have put your point system back into play, make sure your employees know that. Again, no surprises in employment. You told them that you were taking it off the table. Make sure you tell them it's back on. These are some more nice policies. Again, I'll say that some of them should be required. I'm going to skip to holidays for a moment. I always recommend that holiday policies should not list the holidays. Just state that every year by January 1, a list of holidays for that year will be published to all employees. That gives you tremendous flexibility. So for example, again, if you've had some economic hits because of COVID and you need to eliminate the day after Thanksgiving as a holiday for this 2021 year, it gives you the flexibility to do that. But when you publish it in January of 2021, if it's still on the list, then you've made a promise to your employees that it is in fact a holiday. So be careful, but it does give you some flexibility. Also, a lot of communities that I've been in touch with are designating Juneteenth as a holiday for their community, for their city or whatever. And a lot of the companies in that city have taken that up and they're going to add that to their holiday list. So just saying you're going to publish it in January gives you the flexibility to add or subtract. Inclement weather, we don't get a lot of it, but we get enough of it that it usually scares people. I was born in Philly, so inclement weather shouldn't scare me, but I drive a sports car, so it does. But I will tell you that in Philadelphia, 3 inches of snow doesn't shut down schools or businesses, but it does here in South Carolina. In certain rural communities, even the threat of that is enough to shut down schools and businesses. And so our employees should know what to do if you shut down, or what to do if you don't shut down, but they're afraid to drive because the weather is a little sketchy. They need to know what to do if they come to work and then get sent home at noon because the weather is starting to get a little crazy. So all of that should be in this policy. And also the most important thing that employees want to know, when do I get paid? If I can't come to work, do I get paid? If the company tells me not to work, do I get paid? So all of those things need to be in that inclement weather policy. And that's federal law, by the way, so it's not something that you as a company decide. Secondary employment, I am not a fan of asking for forgiveness. I am definitely a fan of asking for permission. I don't want to find out that my lead engineer is working at Lowe's on the weekends. I need to know that he's working there. I need to approve him working there. And you as the primary employer have the right to do that. Your secondary employment policy should tell the employee that prior to accepting secondary employment, you need to come to HR and explain what the job is, and your supervisor has to sign off on it. And even though we've given you permission to accept this secondary employment, we reserve the right to rescind that if we believe that it conflicts with our business or it's interfering with your ability to do your job here. You also want to have a caveat in there that says our workers' compensation employment insurance will not cover injuries and accidents that occur at your secondary employment. Now I'm going to tell you all that it's very difficult to monitor that, because if somebody gets injured working for the local feed and seed and they don't have workers' comp insurance because they don't have to, your employee comes to work that following week, slips and quote falls in the men's room, and now you have a workers' comp claim. It's going to be very difficult to tie the two together, but sometimes the fact that it's in a policy helps you with the workers' comp commission. Personal appearance, this is it's a nice policy to have. It's really, you just have to be careful. I think one of our HR cafes, we talked about the requirement of a clean shaven face. You can't do that. Be careful of what you require or prohibit based on religious observance, things like that. So personal appearance policies are nice, but they're also problematic if they're not written correctly. Work breaks. Okay, so there's a myth out there, it's an urban myth, that employers have to give employees work breaks. And I've heard employees say, well, you have to give me a coffee break in the morning and a coffee break at night. No, employers do not. Or then my personal favorite, you have to give me a lunch break after I work 4 hours. No, show me the law that says that. Now, you may have a collective bargaining agreement that says that. There's no law that says it. However, we as employers would be very foolish if we did not provide those breaks. We wouldn't have employees for very long. They'd get tired and be injured and things like that. So we do want to provide breaks. It's a nice thing to do. It's the right thing to do. However, because it's not regulated by state or federal law, you want to put some caveats on those breaks. And so your policy should say that there is no federal or state law that requires us to provide work breaks. But we do, because we're nice guys. However, if business needs supersede the time where your break should have occurred, we're going to try to reschedule your break as best we can, but those business needs are going to come first, and we may have to cancel or reschedule your break. Put it in the policy, they're not surprised. I circle back to social media and bullying because since the unfortunate incident with George Floyd and his death, I have probably had 12 to 15 calls from employers who have had employees who have posted extremely inappropriate things on social media, both racially, in a harassing tone, in a bullying tone, just horrible, horrible stuff, y'all. It just sets me back to think that people can actually, in their mind, think that this is okay to put this kind of stuff on social media. And then, of course, when you sit down with the employee, they argue that they have a First Amendment right to say whatever they choose. That's not true. And so your employees need to understand the constraints on social media. And we are all entitled to our opinion as long as our opinion doesn't break other laws. And these posts were, in fact, breaking other laws. They were harassing, they were bullying, they were intimidating, and they were racially motivated. So make sure your employees understand that won't be tolerated. Now, if you're in a public sector, that's a whole different ball of wax, because public sector is governed by the United States Constitution. So in the public sector, you have more of a First Amendment issue that you have to carve out than the private sector. Private sector, you're not covered by the First Amendment. You may think you are, but you're not, again, if you're breaking other laws. So make sure your social media policy covers that, and make sure your employees are trained on that. And bullying is no different than harassment and discrimination. So if you've got a case of bullying going on, you need to address that immediately. Okay, so let's look at some policies that may be required by law in not too long from now. Harassment, discrimination, it could be argued that Title VII of the Civil Rights Act of 1964 requires us to have a policy. It doesn't really state that in there. There is case law that says that we have to train on these things. There is case law that does say we have to advise our employees of our rights, of their rights under Title VII. Again, you've got a poster somewhere that's got this on there, okay? Same thing with retaliation whistleblower. But employees should really see it in a policy. I probably most of your employees go past those posters and don't read them. I can tell you that I've polled employees and I've asked them, how many of you know where the posters are that explain what your rights are under workers' comp and Fair Labor Standards Act? And out of a group of maybe 50, I probably got 2 or 3 hands. Your employees don't know where those posters are, but they know where their handbook is. And again, this goes back to my argument for training. It's in the handbook, you train on it, you tell them it's in the handbook. And so if they're starting to feel harassment or discrimination, they'll go to the handbook. They're not going to go try to find a poster. Marijuana, opioids, we've had a lot of chatter about this. Marijuana, legal marijuana has been on the docket for South Carolina General Assembly for a long time, keeps coming off. It is legal in certain very rare instances, but I will tell you that there are vape cylinders that are marijuana loaded. And so you may have your employees who are vaping marijuana and you don't even know it because there's no odor. So if you have a no smoking policy, I would add vapes to that. There's no smoking on the premises, including e-cigs, vapes, that sort of thing. So if they are smoking marijuana in their vape, then let them do that at home. And then if you're drug testing, you'll find out at some point. Opioids, you may all know that there's major opioid litigation going on right now. 2 of the companies that have been sued have already filed for bankruptcy. Opioids is a serious thing. This is a national epidemic that we've been dealing with for years. And in South Carolina, no kidding, it's very serious. So right now, you cannot ask employees if they are under the influence of opioids. You can randomly test, you can pre-employment test, and certainly you can reasonably suspicion test as long as you're careful. But we probably, once the litigation is completed, in about 18 months, I'm thinking, we may see some policies that will be required because of the opioid epidemic. LGBTQ, just recently, the United States Supreme Court ruled that the 2 cases they heard last November told the Supreme Court that the LGBTQ community is protected under Title VII. Now, the black letter of the law, the actual written law, doesn't say that. It doesn't say LGBTQ, but the court's interpretation of the protected class of 6 says that it's broad enough that it includes LGBTQ. Supreme Court is not allowed to legislate from the bench. They're not allowed to make law. They interpret law. So essentially what they did was legislate from the bench. So I think there'll be a little bit of backlash on that. Hopefully Congress will clean it up with an amendment to Title VII. It should be that easy. And so I'm hoping that they will do that. Doesn't matter. In the meantime, we have a Supreme Court ruling that says LGBTQ community is protected from discrimination and harassment and retaliation. And so your policy should reflect that. All right, I promised I wouldn't talk too much about COVID, but we have to talk about it a little bit. So these are some policies that we may want to think about because of COVID-19. Many of us learned a very valuable lesson when our employees didn't come to work because we closed our doors to minimize exposure. But we had some employees doing telework, and there were some jobs that we found telework very nicely, transitioned into telework and seamlessly. However, we need a policy on what employees are supposed to do when teleworking. How are they supposed to sign in for the day? How are they supposed to record their hours? How are they supposed to transmit their work, particularly if they're working on some sensitive or highly personal information? Say they work for HR. You don't want them emailing documents that have Social Security numbers on them and so forth. So all of that should be fleshed out in a telework policy. Also, workers' comp has to be addressed. If you have an employee who's working at home and they trip over their child's build-a-blocks, is that a workers' comp claim? It will be. And so we need to have some type of caveat in the telework policy for that. Hours worked, very important. Fair Labor Standards Act has not gone away. I think COVID sort of overshadowed everything, but it's still there and we still have to worry about it. I was on a webinar yesterday. Yeah, I think it was yesterday. And every so often this little screen would pop up and say, "Are you still there?" And I'd have to click on yes, because if I didn't, I wouldn't get the continuing education credits for it. And it was an hour and a half long. And literally you couldn't time. I started trying to time when that little screen would pop up and there was no rhyme or reason when it popped up. And so it made me stay on the call. If your IT people know how to do that, that might be something you want to do, or have the employee check in by Zoom or Skype every 15, 20 minutes. I think that's kind of burdensome, but that's certainly up to you. But I would have them check in at some point in time. Cross-training, I think we learned a lot about cross-training. So if in your organization, your payroll clerk lost her child care, and so she had to stay at home, she could potentially telework, but payroll is very difficult to do teleworking, and so she couldn't. Or let's say worse, she got COVID. If we didn't have anybody else cross-trained on payroll, our people didn't get paid. Somebody had to scramble to try to figure that out. So we learned a very valuable lesson because of COVID. Make sure you've got cross-training. Make sure you have plan B. It's really what it is. And I hate to say this, this is not the first pandemic we've had. It's not the last pandemic we've had. We're treating it a little bit differently than we did others before it, but we're learning lessons from it. And so be prepared for the next one, or be prepared for the next snowstorm, or what have you. So we have other emergencies besides pandemics. Cross-training and telework really should be policies you have, and procedures also. Your supervisor should understand how to do those. Safety, you're going to have to do a deep dive into your safety policy. You're going to have to take a look at all sorts of questions as far as sanitary issues. What are we doing with letting how many people in the door? And right now we're up against Governor McMaster's executive orders. He's up to number 50. I've read every one of them. We're not finished with that. There's going to be more caveats. He's just drafted down a lot of the things that he had opened up. So I wouldn't do your safety policy just yet. I would be familiar with it. If you have a safety person or a safety department, get them to start thinking about it, because you are going to have to change your safety policy. Who'd have thought that we'd be wearing masks and gloves, and who knows how to appropriately dispose of those things. I watched somebody the other day, an EMS worker, and not from Chester County, but an EMS worker, take off his gown and shake it. And I thought, oh, no, don't shake it, because you're just distributing all the particulates that are on that gown. So those things, if they're not in there, you're going to want to have some strengthened bloodborne pathogen information in there, and infectious diseases. Don't call your infectious diseases policy COVID. As I said, we don't know what, and look at it, it's COVID-19. That's because it was discovered in 2019. But the real name of COVID-19 is SARS COVID-19, because it originated from SARS. And so we have no clue what 2021 is going to bring us. Write your policy as infectious diseases. Many of you may know that FMLA was expanded for folks who have lost childcare. The FMLA, it's called EFMLA, extended FMLA. It is only for childcare loss. Oh no. Okay, sorry, are we there? Did I lose everybody?
You're still good.
Good, sorry. Okay, so I'm just going to keep on talking while this thing goes crazy. So FMLA is for loss of childcare. If your employee lost childcare, they have the ability, and I don't know how to get back here. There we go. They have the ability to ask for time off. Under FMLA, they get 12 weeks. Until the end of this year, the first 2 days, first 80 days are paid. Thereafter, they get paid 2/3 of their regular wages up to an aggregate of $10,000, okay? The maximum per day for the first 2 weeks is $200. That ends the end of this year. Do not revise your FMLA policy until such time as Congress has decided what they're doing. They're working on their next stimulus package right now. And the House wants to put in there that this EFMLA is permanent, that it's not going away at the end of December. So that would mean any employee that you have who loses childcare, not just because of COVID, but who loses childcare, can have their first 10 days of leave paid. And thereafter, 2/3 for the next 10 weeks. So stay tuned on that. Again, don't change your policy because we have no idea what Congress is going to do. The House wants it permanent, the Senate does not. Sorry about that little blip. Okay, so employee handbook versus policy and procedures. I've already kind of touched on this. Policy and procedure is strictly how to, okay? It's instructive. Your handbook is just policy. It doesn't have the how to in it. And policy and procedures manual should not be given to employees. They don't need to know how to. They just need to know what the policy is. Be very careful that your practice doesn't become policy. I recently reviewed a handbook for a client, and she kept saying, but that's not what we do. That's not what we do. And I said, but that's what your policy says. She says, oh my, this is a problem. That really does become a problem. And that's where challenges to you legally will fail if your policy doesn't match your practice. So make sure you've got consistency there. These are some epic failures I've seen on handbooks. Just said inconsistency, that is major problem. Practices and policy, another problem. Your handbook is 10 years old. If your handbook is 10 years old, I can't tell you how many laws have changed in 10 years. Between laws and case law, that handbook, you might as well just burn it. There's no reformation for that handbook. If it's 5 years old, it's going to be a little easier to update, but not much easier. No training on handbooks. All too often I see employers hand out the handbook at onboarding, and that employee gets no training. And I don't mean, 40 hours on training on a handbook, but at least hit the high points. So during your onboarding, you should have some training of what the employee must do if they need time off, if they need FMLA, where, when, and how they're going to get paid. Those things that are important. Handbooks that are not updated when laws change. Remember, not just law, but case law. Our Supreme Court, United States Supreme Court, with their changes, they affect your policies. No disclaimer is a super huge problem. Super huge. This law has been around since 2004. It is not new. If your employee handbook does not have a disclaimer in it, you really need to get one going, or one that doesn't pass muster. Your disclaimer and your acknowledgement, oftentimes for employers, are one document. They should not be. Disclaimer says, I understand this is not a contract and my employment is at will. The acknowledgement says, I've gotten the handbook. I understand it's my responsibility to read it and understand it, and also my responsibility to ask questions if I have any, and I promise to abide by the rules therein. They say two different things. Also, the disclaimer has to be on the first page. The acknowledgement doesn't even have to be in the handbook, and it really shouldn't be. Should be in the employee file. And so I've mentioned several times revision. How often do we do that? HR should review it every year. And again, I know you've got so much to do, but it really should be revised, at least review it. Legal should review it every 3 years. Anytime you get a new court ruling, and I know y'all don't have time to necessarily watch all the court rulings. You really should depend on your corporate counsel or your employment counsel or whomever it is. SHRM's pretty good about making sure that y'all know about court rulings. And so if you're watching the SHRM legislative updates, it should be in there. New legislation that gets passed, if you're relying on SHRM, you're going to miss the state stuff. SHRM only really pays attention to the national federal laws or California, because California has such crazy laws. And so I know, again, that's a lot on y'all, but it's unfortunate that you got to do it. Okay. And so after you revise, what do? I like handbooks where I can make sure my employees have really put that new policy into their handbook. Make it easy to put in. So use a 3-ring binder or something like that. At the bottom of all your new policies, put the date so that your employees can easily see what policy is the newest one, and they'll remember to take it out a little more easily. If you have something that you went and had it bound with hot glue and it looks really pretty and all of that, every time you need to revise it, there's no way the employee can insert it in that book. And so what happens is it gets shoved in the back, and when they're looking that same policy up, they're still looking at the old one because they've forgotten that they shoved the revision in the back. Every time you revise or you add a new policy, get a new acknowledgement. Here is again why the acknowledgement should not be the same as the disclaimer, because you want to make sure that if you're going through the history of an employee, you have an acknowledgement for every new policy that you put out there. Revision should be followed by training. And now here's my disclaimer. I know how busy you are. Remember, I was an HR director in my other life. I get it. And I will tell you, we hear a lot about first responders, EMS, fire, law enforcement, nurses, doctors. Everybody during COVID, the heroes, right? We've all heard about the heroes. In my world, they are all heroes, no doubt. But they need to include HR people, okay? HR professionals are the heroes right now. Y'all are dealing with all this crazy employees who come to work sick, employees who have temperatures. How do I get my employees back? What do I do with this unemployment? What does Families First require? I get that. I really do know that. And my hat's off to everybody in this meeting, because you truly are heroes. Somebody else needs to add y'all to the first responder list. But this is important. It was important enough to you today to be in the meeting. And so make it important enough to you today to go back and look at your policy, check for some of the things that we talked about, see what you can change quickly, and see what's maybe a long-term project, see if you need to get help with it. But do take the time, since you took the time to do this today, to go back and look at it. And so these are some of the handbooks that I've seen. Virtual, they're fine. Make sure you have the signed disclaimer. Okay, even if it's virtual, get an electronic signature, put it in the policy, in the file. Make sure if you're virtual or portal, you have that disclaimer in that personnel file. Just having it online is not going to be enough. Paper, I still see many clients resorting to paper handbooks. They like it. I'm not sure why. They just like having it. And so really short handbooks, I've seen some really short ones. I've seen some really long ones. And then I've seen clients who have nothing at all. And the conversation is, well, if I don't have it in writing, then I don't have to abide by it. Oh my gosh, did you just say that out loud? Because you do need a handbook in many of the circumstances I mentioned. I mentioned policies that are required. And so do you just hand your new employees a bunch of papers? That's not good. The our one rule that you see to the right of the types of handbooks, use good judgment in all situations. This is literally a handbook of a client. This is it. This is page 1 and end. So that's their handbook. I'm not sure that would pass muster. They fortunately haven't had any legal challenges yet, but I don't think that will pass muster. It doesn't address Fair Labor Standards Act or FMLA or wage and hour, none of that. But that's their handbook, and they feel that that will suffice when they get a legal challenge. I don't think that's good. I don't think your handbook should be an epistle. If you have a handbook that's 200 pages, No one, including me, is going to read that. Make it to the point, make it palatable, make it easy to read, easy to find stuff. Really long isn't going to work. None at all isn't going to work. And certainly our one rule is not going to work. And we are finished. I'm open to any questions that you may have. If I turn the camera on, you will be looking at the back of my computer, so I'm not going to turn it on. But I'm absolutely happy to take any questions that anybody may have.
And if you guys want to unmute yourself, if you are on a computer, you can just hit the unmute button. But if you're on the phone, *6 will mute and unmute you. Or you can use the chat box off to the side if you don't want to talk to anyone. Some people aren't comfortable talking. I get that. I'm not that girl.
No, me either. And the other thing that y'all can do, if you have a question that pops up later, after you actually do get into your handbook, send me an email. Y'all have my email address. If you don't, you can send it through the chamber and they'll filter it through to me. I always tell y'all, you get one bite of the apple. So if you've got a question, send me an email, call me, whatever. If you call me every day, if you email me every day, you're a client and you'll get a bill. But if you just do it once or, as a follow-up, I'm always happy to help. So, and it doesn't have to be related to the handbook.
I'm looking and I'm not seeing anybody popping up with anything. So like she said, if y'all have questions, let her know. And you can always forward them to me as well. I will be probably before the end of the day today, I have this video processed and each of you will get a copy of it, of the presentation, as well as the slides that she went through, and I will attach those and send those out before 5 o'clock today. So keep an eye out for that. Joanie, thank you so much for doing this for us today. We really appreciate it.
My pleasure. I look forward to getting together with everybody live and in person at some point soon.
I know.
End of the year. Yeah.
Fingers crossed it'll be soon. So
Absolutely.
everybody have a great weekend.
Yeah.
All right. Thanks.
Thanks, everybody.